Thank you very much, CA Priyanka Jain. A warm welcome to all of you. I hope everything is fine. First of all, I would like to thank our guest speaker, CA Hiral Shah, for accepting our invitation and giving us that time, your valuable time, and also a warm welcome to you also, sir. And this is a different topic, will, nomination, and drafting of will, because our members, I don't think many members are involved in drafting of wills or in all these things, because whenever our client asks for this, we said you can go, you go to the this advocate or this advocate. But yes, at least we must have the knowledge of drafting of this nomination and the will. That's why we are going to organize this webinar, and really people are appreciating for this this webinar. And even few members are saying ki, why you are organizing this webinar at the time of COVID? Don't uh, take it otherwise, because this is only for knowledge purpose, not for anything else. So my request to Priyanka, give a brief introduction about our guest speaker. He's from Mumbai, very dynamic and very learned speaker we have, and he will guide us about the drafting of nomination and the will. So now it's over to Priyanka, please.
Thank you, sir. CA Hiral Shah from Mumbai. He is practicing chartered accountant since 2006 and has completed his LLB from Mumbai University. He is also qualified DISA and many certification course from ICAI. Further, he is managing committee member of GST Practitioner Association of Maharashtra and CA Federation Jain Association. And he is faculty for Abo Association. He is regular faculty for Bombay Stock Exchange and Rotary Club and many association. Thank you, sir.
Now over to you, sir. Please guide us regarding this will, nomination, and drafting of will. Yes, member are interesting to listen. Yes, please.
Thank you, Vivek ji. Thank you, Priyanka ji, for the warm welcome. I'll try my best, and we put our experience into it. What is normally seen with, let me start, where there is a will, there is a way. Yes. So let's remember the fact that will is not only going to break a way for us, break a way ahead, but we are here to understand the different myths that people have with respect to will, with respect to different nomination, the interchangeability thereof, and what are the simple steps that we need to keep in mind at the time of drafting of will. Though people generally say, "Arey Hiral bhai, you are a chartered accountant, will drafting of will should be an advocate's job." It is not so. I would say, okay, by qualification, whether I have done my 3 years as a law graduate also. However, this does not make a difference. A layman himself can go ahead and prepare a will, but will is necessary. It is very much imperative that everybody prepares a will for himself, for the family members. It is good for the future generation as well. Let me take everybody further. First and foremost, why is succession planning important? See, today, okay, I am there, I am sitting the main member of the family. May it be your client, may it be you, anybody. Still, why is it important? Because after the person is no more, there has to be a smooth transition of assets from the deceased person to the legal heir, whoever is supposed to get it, whoever is entitled for it. So that smooth transition, for happening of that smooth transition, succession planning is important. Who would get the control of the end use of the wealth which is there with you? The control and the end use of the wealth is very important. It plays a very, very important role, that the control remains with you as such. Succession laws. See, succession laws are very opaque in our country. There is no transparency as of now with respect to different people, because what happens is that today a will is made. If the will is not made, if the planning is not done today, then you would have a problem later on. So the succession laws, this, no, you fall into this bracket, you fall into that bracket, rather not go in for it and remain safe. Estate duty, inheritance tax. One thing, post this budget, post the last budget, what is being circulated is, array, there is going to be inheritance tax, there is going to be estate duty which is coming, which is there in the pipeline. People, even without the knowledge of the honorable prime minister or the finance minister, everybody started saying, nahi, nahi, estate duty to aa hi gaya. Ab dekho, inheritance tax aa hi gaya. As of now, it is not there, but that planning is very important right from today itself. Life is uncertain. Nobody can say कि okay, I'm going to live 100 years. मेरे को ज्योतिष ने बताया कि मैं 100 साल जीने वाला हूँ, तो 90 साल का होऊंगा तभी मैं will बनाऊंगा. No, that is not correct. There is litigation. We have seen with big business houses as well that when wills are not made, there is litigation, there is unnecessary litigation between the parties, and that creates a problem going ahead further. Modes of succession. What are the different modes in which the succession takes place? It is after the, see, there are two kinds. You can plan for succession right from today itself, or you can plan it at a later point of time. So during the lifetime also succession planning can be done with respect to creation of a beneficiary trust, a private trust, family trust, all those things. However, today we are not dealing with transfer during the lifetime. We would be dealing with what after death, transfer of assets, succession after death. So there are two ways going ahead. One is intestate succession, second is by way of a will. Therefore, I'll explain the difference between the two. First, we will start with intestate succession, then we will go ahead with will. I would like to state here that in case the will is not made for Hindus, and Hindus includes Jains, Sikh as well in the fold of the definition of Hindu. So in case the will is not made, then the estate and the succession goes as per the Hindu Succession Act 1956. In case the will is made, then the Indian Succession Act 1925 plays a role, and the will as such is the most important over there. Testate and intestate succession of Christians, Parsis, Jews is governed by the Indian Succession Act 1925. Here I would like to give a small disclaimer that here I would be speaking about the Hindu Succession Act only, and the testate succession with respect to Indian Succession Act. However, my talk would be restricted to the Hindu Succession Act only, the succession for Hindus. Now, how is the property devolved to the legal heir when there is no will? When a person dies without a will, it is said that he is said to have died intestate, okay, without a will. So the properties of the person who is no more with respect to non-making of a will, it is governed by the Hindu Succession Act, as I said. So the definition, now the will is not made, so it is divided into two parts. A male Hindu dying without a will and a female Hindu dying without a will. So male and female are divided, and then what is taken further is for male Hindus, it is okay, a male Hindu is no more, so then it the property devolves to his relatives. Those relatives are also divided into two parts. First, class 1 relatives. It is known as class 1 relatives, means in general parlance we can say ki, okay, the near and dear relatives, the first relations, first relationship goes for a male Hindu. It is known as class 1. If none of the class 1 relatives are alive, if all the class 1 relatives are dead, then it goes into the class 2. So, and if there is no relative from both the classes alive, and then it cognates, so then there are further streams. So we concentrate on class 1 relatives and class 2 relatives for intestate succession of a male first, and then we'll go to the female. So, in case of a male Hindu dying intestate, who are the class 1 relatives? So, class 1 relatives includes the son of the Hindu male who has died intestate, the daughter, the widow, the mother, son of a predeceased son, daughter of a predeceased son, son of a predeceased daughter, daughter of a predeceased daughter, widow of the predeceased son. Now let's take it with a kind of an example. So normally what happens, many a times we have seen that people have this notion that okay, if I'm dead, my property will go to my wife. Wife is dead, property will come to me. If both of us are not there, then it will go to a third person. This is just with relation to the understanding. A common man understands it this way, and they speak about it this way. However, that is not the case. The correct case is if there is even a lakh of rupees. Say for example, a Hindu has died with just 1 lakh rupees. So then it is divided amongst all these class 1 heirs in equal proportion. It is not that the widow will get everything. Even if it is a lakh of rupees, it will not go directly to the widow. It will be divided amongst these people equally. So it is very important that you have to see all these relatives. At times it so happens that due to any XYZ reason, the son is not in talking terms. He's not taking care of the parents, and then after the death of the father, the son comes, give me my right. There is where the Hindu Succession Act plays. Son would definitely get his right, or a daughter would definitely get his right, her right. However, if the will is made, then it is a different story altogether. So, if none of the class 1 heir, so this is just a representation of the legal heir thing that I told. Mother, wife, son, daughter. If the son is not there, then the son's wife, daughter, son, they get a right. If the son is not there, then they get a right. If the daughter is not there, then it goes to the son or daughter. So it is basically divided amongst mother, wife, son, daughter. If the son is predeceased, then it goes to his legal heir. Now, devolution of the property when no will is made and class 1 relatives are not there. So if class 1 relatives are there, they get the right. Otherwise, it comes to class 2. So if you see in the previous slide, as I said, the class 1 relatives. Class 1 relative includes a mother. It does not include the father. If none of these relatives are present, then it goes to the class 2 relatives, and class 2 relatives starts with father. Then son's daughter, son's daughter, brother, sister, daughter's son's son, daughter's son's daughter. So it is divided further in the family tree. Basically, we understand it from the family tree point of view. order and succession and manner of distribution amongst the heirs of the dying Hindu male shall take place as per section 9 to 13 of the Hindu Succession Act. It is very important for us to understand the Hindu Succession Act. Section 9 to section 13 describes the manner and the order. However, we just discuss the order. First, it goes to the class 1 relatives. If class 1 relatives are not there, then it goes to the class 2 relatives. So that is very clear. Now, another thing which is worth mentioning over here is wherever we mention the things like wife, son, daughter, all these terms include illegitimate wife, illegitimate son, illegitimate daughter also. So how to prove those things? That is a different story. However, these are included, and this creates a major problem when the property is to be devolved without the relatives being without the class 1 relatives and without the will being very specific about things. So that is something which we need to look at. In case of female Hindu dying intestate, so first we spoke about a male Hindu. Here we are talking about a female Hindu dying without the will. See, at times we think कि अरे फीमेल का क्या है, ठीक है, सब मेल ही हैंडल कर रहे हैं. It is our society is male dominated, male is handling, तो ठीक है मेल का ही will बनाएंगे. But again, our society has major things. Today we invest. Okay, I invest a property, it will be in my wife's name. When my father invests, the property would be in my mother's name. So at times we take it that way. So it is very important for us to see that even the Hindu female has these rights. So the Hindu female dying intestate without making a will. So first it devolves upon the sons and daughters, including children of the predeceased son or daughter, which is quite the similar case in case of a Hindu male dying. And it goes to the husband. So firstly upon the sons and daughters and the husband. Okay, so it is that way. Secondly, if the first ones are not there, then upon the legal heir of the husband. Now if the sons and daughters are there, husband is there, it will go to them. If they are not there, then secondly it will go to the legal heir of the husband. Then it goes thirdly to the mother and father. So mother and father of the Hindu female, it is not the mother-in-law, father-in-law, it is the mother and the father of the female who is dying. Then in case the mother father are also not there, then it goes upon the heir of the father, and lastly upon the heir of the mother. So nowhere, everywhere it speaks about, okay, the Hindu female dying upon her family, and when it is not upon her family, then it goes towards her parents, not towards her in-laws. That is to be noted and to be very careful about. So in case of a Hindu female dying without leaving behind any son or daughter, or the children of the predeceased son or daughter, so it will devolve upon the heir of the father or the mother. It would not devolve upon the in-laws. Any property inherited by a Hindu female from her husband or from her father-in-law shall devolve upon the heir of the husband. So here it has been made very different. So there is a bifurcation, that if it is the husband's property which has come to her, or the father-in-law's property which has come to her, then it will go back towards them only. Again, order of the succession and manner of distribution has been defined and provided under section 16 of the Hindu Succession Act 1956. Now, will. What is the will? Will has been defined as a legal declaration of the intention of a person with respect to his property, which he desires to take effect after his death. It reflects the last wishes of a person for the manner in which the property will be divided post his death. So, uh, definition is good. The will is as per law of succession. It goes if the will is not made, that is the estate planning portion of things. Basically, will is a document which would come into effect after the death of the person, not before that. It is only after the death of the person that the will would come into effect. What will is the willingness of the person who wants the assets to be retained or disposed or whatever after his death. Now, when so firstly we spoke about what happens, how are the assets distributed if no will is made. So we come to the conclusion, okay, कि चलो, okay, we'll make a will, but we have certain notions in our mind which hamper us, which distract us from not making a will, for not preparing a will. You know, it the first thought which comes to mind, okay, a client has come to me, I ask him, generally as a social service, as a social courtesy with our clients, we ask them, hey, आपने will बनाया है कि नहीं बनाया है? अरे विल क्या बनाने का, विल तो टाटा बिरला अंबानी के लिए होता है, हमको विल बनाने की क्या जरूरत है? हमारे पास कौन सी इतनी बड़ी एसेट्स है, अपने पास कौन सी इतनी बड़ी प्रॉपर्टी है? However, when we speak about the value of property in Mumbai, where I am sitting, or in Delhi, or across the country, wherever we are thinking about, the property rates itself are pretty high. So, and wherever a person has, whatever a person has earned during the life, whatever he or she has accumulated during the life, that is as per their social standing, it is as per their standing. Whether the amount is low or high does not make a difference. So this mindset, this aspect has to come out of the mind, that will is only required by rich people, will is required by every individual. The next thought, as Vivek ji said, ki why have we kept the lecture on will under these circumstances of COVID running around? This death is not a pleasant thought for anybody. Today, all of us are scared for COVID-19 going on somewhere. This is declared as a contamination zone. My building is sealed. This building is sealed. Such things are happening. Death is definitely not a pleasant thought. However, will and death do not have direct correlation to each other with respect to preparation thereof. I have prepared a will at the age of 33 does not mean that I am not going to live for 93. I'm not going to live up to 103. Making of will does not by any ways determine when you are going to die. So when people come to us, that the thought is there in mind. Today I am preparing a will, I'll die tomorrow. No, keep that out of mind and prepare a will. Though that is not a pleasant thought, it is known, it is for sure. Each of us is going to die someday or the other. So why not prepare it for it from today itself? Another myth or a wrong notion which people have is that they would lose the control over the assets. If I make a will today and I give it over, then my children would not give me this. I would have to beg from them the property which I have generated during my lifetime. I should enjoy it. Fine, that is absolutely correct. The wrong notion is that the control of the assets would be transferred to some other person when a will is made. That is a very wrong notion. It is the assets do not go to anybody. You are in absolute control of the assets till the time you die. Another aspect is avoiding awkward family discussions. Correct? Very true. Family discussions, they are going to be there. However, at the end of the day, the property that you have generated, the property which the male member, the female member have generated during their lifetime will be given as per their direction. If you have that feeling that, okay, if I prepare a will today, if I discuss with my family, discussing with the family, if possible, it is the best before preparing of will. However, if such a thing is not possible, you feel that if I start discussing today, I will have parted ways with my family right from today, then you can avoid such family discussions and you can get it prepared without discussing with the family also. So it is not necessary to discuss with the family, though it is advisable, but when it is not possible, it can be really ignored. Another aspect of hesitancy in sharing private wealth data with consultants. Okay, I am sitting over here. It is, people say, काले कोट से और सफेद कोट से किसी को कुछ छुपाना नहीं चाहिए. If you go to the doctor and you don't describe your ailment in detail with them, they would not come to know what is the exact problem and the exact solution wouldn't be available. Similarly, on professional basis, when it is with us professionals, we have professional ethics with us. So then there should not be any hesitancy to share private wealth data. Now, when we are talking about chartered accountants normally know in and out of the person. Even if you have a family advocate would know the in and out of you. So then there is low hesitancy when it is your own professional, your own family member. A chartered accountant or an advocate is your family member. So there should be no hesitancy in sharing the private data. People have the notion कि अरे ये will बनाना बहुत complicated है, बहुत खर्चा होता है उसके अंदर. Okay, if you are thinking about the expenditure that you are going to incur today, then might as well think that it is quite low as compared to the expenditure which your legal heir would have to incur if the will is not made. So the expense is peanuts as compared to what your family members would be paying at a later point of time. So expensive part is taken care of. Complicated, it is not at all complicated. It can be made by a person himself. It can be made by us chartered accountants. No need for a solicitor or a specialized advocate to do that. Though there are points which I would cover that they are to be taken care of, and that takes care of things pretty easily. Tendency to procrastinate as it is not time bound. What we believe in is 30th September ऑडिट का ड्यू डेट है, ऑडिट कंप्लीट करना है, क्लाइंट का कंप्लीट करके देना ही है. 31st जुलाई रिटर्न फाइल करना है, 1000 का पेनल्टी लगेगा, 5000 का पेनल्टी लगेगा. Okay, we are too busy with that. However, so it is taken. Okay, we'll do it tomorrow. What's the hurry? I'm not going to die so early, so we'll do it. He'll take the client or the person would take the appointment. We'll meet next week for the will. अरे urgent order आ गया, नहीं कर पाया. We'll meet some other day. So this is a blessing in disguise available to us with respect to the lockdown which is there. Sitting at home, we can prepare the will for ourselves. We can inform our clients these basic details wherein they can prepare the will. They can get it prepared from us. They can get it prepared themselves. But it is a social cause that we have to see to it that will is made. So as I said, will comes into effect after the death of the person, not before the death. It is peculiar. It is very important to note that it comes into effect only after the death of the person, not before that. The person making the will in legal terminology is referred to as testator. The person who is preparing the will is known as the testator. He is going to prepare the will, testator. So this word will come pretty many times, so we need to take care of it. It has to be attested by two persons in the law, and they are referred as attesting witnesses. So they will witness that okay, the testator has signed it before us. The will would cover the assets, that is known as the estate of the testator. The testator appoints a person who will administer the assets, because the person is no more. The testator who is preparing the will, who is making the will, is no more. So you need somebody who would execute the will, who would take the wishes of the testator who is no more, take it forward. He is known as the executor of the will. The person or persons who receive the benefit of the estate are known as the beneficiary or the legatee of the estate. So these are the 4-5 terminologies that we need to see. We will describe it later as well. And what are the points that we need to be careful about? The will made by a Hindu, Buddhist, Sikh or Jain is covered by the provisions of the Indian Succession Act 1925. As I said, wherever I am taking the word Hindu, Hindu includes Hindu, Buddhist, Sikh or Jain. These minority communities, the Jain community, Sikh community and Buddhist community, for the purpose of the Indian Succession Act, for the purpose of Hindu Succession Act, are governed and termed as Hindu only. Now, when we want somebody to prepare a will, or we want to prepare a will ourselves, first we need to know what are the benefits of making a will. A will is a document of all properties. No separate documents like sale deed, transfer deed, gift deed for each property needs to be executed. Here we get questions that I want to prepare a will for my property at so and so place, or some property at so and so place, some property located in Delhi, some in Gurgaon, some in Noida, some in Mumbai. So but I have properties all across the country, but I want to prepare the will for my property at Noida. So such a thing is not allowed. It is a document for all your properties. All properties have to be mentioned therein. No stamp duty is to be levied on the will. Some of the general queries that comes to us is, will has to be on a stamp paper, sir? No, there is no stamp duty to be levied on the will. So will can be on a plain piece of paper, a normal paper. No special paper is required. No stamp paper is required. No stamp duty has to be paid on it. However, at times we recommend clients to prepare a will on a stamp paper, any stamp paper, 100 rupees, 500 rupees, any stamp paper. The reason therein, it is one psychological benefit. If the document is on a stamp paper, so it looks, अरे कुछ कोई document है. If it is a normal document, हाँ ये कुछ लिखा हुआ है. So that psychological impact is there if it is on a stamp paper. Just a psychological impact, it is not necessary. Psychological impact second, the stamp paper always has a date on it. Date is mentioned on the stamp paper, so that document proves, okay, it was prepared on so and so date. It is not prepared before that, it is prepared after that. So that date, tallying of the date becomes easy if it is on a stamp paper. Again, to be very clear, it can be on a simple piece of paper, not a stamp. A stamp paper is not required, not necessary, not mandatory. As I said, that the properties of the testator continue to remain in his hands and can be enjoyed by the testator during his lifetime without worrying about its distribution. Property is not given to anybody, it is not distributed, it continues to remain with the testator and it is in his hands only and he can enjoy it during his lifetime. No need to distribute it. The power is completely with the testator. It does not pass on to anybody, any beneficiary before the death of the testator. The will, preparing of a will, you have many assets. Those assets, okay, if they are mentioned at one place, no, it becomes a checklist. We are used to things like checklist. So this helps as a checklist for all the assets remaining at one place itself. Then the major another benefit, that administration of the estate can be put in the hands of an identified person, that is the executor. So when I die, it is this person who will manage the things before it is distributed to the respective people. Now this is one of the things that we know, we hear in the Hindi movies, the Bollywood movies as such, कि अरे वो उसके पास गया, उसने सब पैसा खा गया और उसकी बेटी को कुछ दिया नहीं, उसके बेटे को कुछ दिया नहीं. Such things are there. So administration, you can easily identify the person if the will is made, that okay, this person, I 100% believe that this person would be one who can handle it effectively to the benefit of the beneficiaries. So that name can be put as the executor. So you are rest assured that it's a good person who would manage the things. In some cases, one or more family members could need more financial security than the other family members due to special needs or requirements. Say the family has a son who is mentally not fit, a daughter maybe who is physically unfit, and they require some financial security. There are three sons. One is a bit not 100% up to the mark, is challenged, say mentally or physically, and requires more financial security because the other members can have their earning. So if you have made a will, then you can provide for certain financial resources to a specific person. Now, as I said, if the will is not made, it is distributed equally across the board. Here, if you are making a will, then you can give a greater chunk, a higher chunk to the member who requires it more as compared to others. Then, if the children of the testator are not capable of taking care of the assets, then a testator can create a trust also under a will. That is also possible. If this is done in the interim period or such things, you can have the estate of late so and so. That is possible. The needs of the making of a will, it completely substitutes the need for a legal heir certificate and a succession certificate to be obtained from the court of law. So will is there. So you have defined who are your legal heirs in the will itself. So you need not go to the court of law to get the legal heir certificate. The testator can create charge over property for daughters, maintenance, and marriage. As I said, I spoke about, say, a physically or mentally challenged siblings or son, daughter, whosoever it may be. However, the testator can also mention that okay, so much property is to be kept as it is for the daughter's maintenance or for marriage or for any other contingencies. So this is the earlier said were the benefits of making a will. So it takes care of it. Why should one make a will? Because you are able to decide who gets what share of the estate, so it can be distributed. Reduces family conflicts, because later on, if it is not there, You might have, most of us would have seen people, brothers not talking to each other because the father because they are fighting for the father's property. So such family conflicts can be reduced if it is mentioned clearly. It enables transfer to non-relatives beyond his immediate family. Okay, at times it happens, and which we have seen many times, that a person wants to give property to somebody, say a servant who has served all his life to the person, and his immediate family members were never taking care of him. Or we have seen cases where, say, a person, uh, the he had no son or daughter. He was alone. His wife had also died before him. So everything was taken care by certain distant relatives who do not fall into class 1 or class 2 relatives. They were distant relatives, but they were taking care of him. He had told us कि मेरे को ये सब पैसा है ना इनको देना है, because they are taking care of me. However, he could not prepare a will and died before that, suffered a heart attack, and he was no more. The entire property went to people who were not taking care of him. However, they were as per defined under the Hindu Succession Act. They were defined, brother's son went to him, though he never took care of him. He never bothered to see to it that his uncle was dead or alive. Still, he got the entire share of the property without doing anything. You can provide for charity. India is a country where we believe more in charity. So after I die, okay, I have 10 crores with me. Out of the 10 crores, 1 crore should be given to so and so charity. So and so good work has to be done out of it, and let my the other successors receive 9 crores, but 1 crore has to be given in charity, so that I can decide if I have prepared a will. Life interest could also be given through the will, that okay, during the lifetime these properties would be enjoyed by my wife. After her death, it will go to so and so person. That life interest can also be given through the will. There are conditional bequests that I said, that reserve so much money for my daughter's marriage and all those stuff, that can also be mentioned. Who are the persons who can make a will? Just excuse me. Who are the persons who can make a will? Any person who is of perfect sound mind, not being a minor. Basically, whoever can contract, whoever can understand contract as per Indian Contract Act. Here it is very specific, section 59 of the Indian Succession Act, that every person of the sound mind, not being a minor, may dispose of his property by will. Most of the wills are made at by aged persons. This is a very big drawback that we face. In fact, this is a point where we need to go ahead and explain people that it is not, age is not related to preparation of a will. I would share my experience. I have prepared a will for myself. It is not necessary that at this age or that age. Today, people who are traveling more are more susceptible to that death. May it be a terrorist activity, may it be any activity, any accident, anything can happen at any age. So it can be done at any age. The law contemplates that the person executing the will should be in perfect state of mind, or is in capacity to known to him he or she is giving away his or her estate. Perfect state of mind is to be highlighted. It is very important that it should be in the person who is giving out the property should be in a perfect state of mind. Persons who are deaf or dumb or blind can also make a will if they are able to know what they do by it. Every person who is of sound mind. So a person, just the mind matters. Being deaf or dumb or blind does not matter at all. No person can make a will under the influence of intoxication or is suffering from specific illness wherein he is not able to understand, say insomnia, certain things wherein your state of mind is not perfect, then the person cannot make a will. So perfect state of mind is very, very important. Bill obtained by fraud, coercion, or importunity is void. Section 61 is very clear. Say with the example, A threatens to shoot B if C or burn his house or to cause him to be arrested or criminal charge or anything. Means basically A threatens B to do a particular thing, to sign the will or to prepare the will in favor of C. So there is any coercion, any fraud which has been done, then it is not valid. The bequest is void, the making of it having been caused by coercion. Any kind of coercion, it is invalid. So, sir, see these points which I am explaining, it is out of the experience that has come in, plus the fact that it is totally personal opinion. Most of the things, okay, what is mentioned in the section, that is something, and what I am saying might not match at some point of time, because it is a matter of opinion, and opinions are like hand watches. Everybody's watch shows a different time, even if it is a millisecond also. Everybody believes that their opinion is correct. Here, whatever I am saying is my opinion, so everybody needs to think about it. Now, Bollywood movies have a very specific thing. It is video recorded that the person is saying ki, I am in perfect state of mind and I want to give so and so property to so and so person. Is such a thing valid? The answer to it is partially yes, partially no. Such a will which is recorded, video recording or audio recordings, such things are governed by Section 65 of the Succession Act, and they are known as privileged will. However, such privileged will can only be executed by soldiers or by airmen or mariner or persons mentioned in the section. So, the execution of such a will, that is by video recording, is a privileged will, and such privilege is not allowed for civilians. It is only for certain persons who are mentioned. Those are, you can say, basically the armed forces. So that is a privileged will. Now, the will which generally we speak about, the general will as we refer to, is the unprivileged will. That is a will executed by a person, except who are mentioned, who are privileged to do it. So persons who are non-privileged are to be under the unprivileged will section. That is the general will which we are talking about. The other types of will are joint will, mutual will. Joint will and mutual will. So joint will, when two or more persons make a will together, it is known as a joint will or mutual will. Say me and my spouse prepare the will together and say okay, after the death of both of us, the property will go to our legal heir. So such things can be done. So joint will can be prepared. However, joint will and mutual will are some things which most consultants, most scholars, the educational scholars, as well as the practical people who are working on it, say no for a joint will or a mutual will, because there are many disadvantages that you are faced with when you are preparing a joint or a mutual will. So it is a single document wherein more than one people prepare it together. But what normally we suggest is having separate wills for separate people. Form of a will. In what format? Now the simplest thing what we hear is, "Arey, will is to be made now." So you prepare a will, you send a format, and we will fill the format, and the will is done. Will is different from a nomination. Nomination is under specific statutes. Here we are talking about a will wherein no specific format has been provided. You can prepare the will in your own format. However, further I will be explaining the different aspects which we need to see while preparing the will. But the format, the form, there is no specific form, there is no specific format. You can prepare it the way you like. Language of drafting of the will can be in English, Hindi, Gujarati, Marathi, whichever language the testator is comfortable in. It can be drafted in that specific language. There is no specification that it has to be in English only, it has to be in Hindi only, it has to be in Gujarati only, that way. Whichever language, the testator understands, it goes as per that. Just a second. Mama, phone काढी नको ना तुला. Phone मत plug. So there is no format. The drafting can be in English, Hindi, Gujarati, Marathi. Now what happens practically is, we have seen cases wherein a will was drafted in English. It was signed in Hindi or in Gujarati by the testator. Now it so happened that the will was challenged in the court, stating that the person who has signed the will does not understand English language. How was the will prepared in English? How was it drafted in English? The person has no intention, has no understanding of the language, has no understanding of English language. Then how could the person understand? Section 74 of the Indian Succession Act is clear that the intentions of the testator should be known. So here in the court of law, it was said that no, the person did not understand English. So the intentions cannot be drawn that his intention or her intention was very different. It was never intended to give the property to son A. It was intended that she always meant that it is to be given to son B. So son A filed. So it can be in any language, and we have to be very careful about the language which we want to use. It is imperative that the form represents that it is made by the testator. So if it is in the own language, in the own mother tongue, in the own thing which the person very well understands, so it is very imperative for that. Will should not be uncertain, unclear, or vague. As far as the bequest made under the same as per section 89 of the Indian Succession Act. It has to be very clear. It can be very simple. You need not have great legal jargons or things into it. It can be very simple piece of paper, piece of writing, wherein whatever the person understands has been just jotted down in black and white. So what are the outlines for drafting a will? So it starts basically with the name and address of the testator. To define who the testator is. If I am preparing my will, I give my name, I give my address, I give my details. These are my details. So, okay, the person is identified. Here, going a step further, I would say, you can even mention the Aadhaar number of the testator. So it is perfectly defined that this person relates to this Aadhaar number. The fact that testator is making the will voluntarily, it has to be clearly mentioned out that he's making voluntarily, he or she is making it voluntarily without any kind of coercion or pressure from any of the parties. Executors have to be appointed while drafting the will. The executors have to be appointed. You have to say that when I'm not there, so and so person will primarily take over the property to be distributed amongst different people. Then another fact that we always mention is list down, okay, according to me, this is my family, these are my family members. So enumerate them in detail. Then enumeration and listing out of all the properties of the testator and the name of the persons to whom the property is to be bequeathed and their share. All the properties, jot them down, keep it divided in a proper manner. Okay, these are the movable properties, these are the immovable properties. The movable property defined as per their further details. Okay, this is the address thereof. If it is an open piece of land, so how do you define the land? How do you understand that this is the piece of land? So define them as much as possible so that there is no ambiguity. Then if you have to define the movable properties, okay, I have bank accounts with Oriental Bank of Commerce, State Bank of India, HDFC Bank. Okay, these branches, these are the account numbers. As far as possible, give at most details which are possible. Then and other bank accounts can also be mentioned, stating okay, as of now I have bank accounts with these banks, and any other bank account in case it has skipped out of my mind, because it is possible. Okay, if you have 10 at the time of filing of income tax returns also, we come across people, that was a dormant account, I didn't remember that that account is also in existence. So such things might happen. So you can have that, define the assets, define the bank accounts, state any other bank account which I might have forgotten. Then in the earlier thing, when we saw that listing out the properties and the properties to be given to so and so person with, okay, this property 50% to this person, 50% to this person can be mentioned. Then further, there are reasons that you are giving out the property to a few children and excluding a few out of them. So that reason for including need not be mentioned. However, if you are excluding certain legal heir from the property, mention that. Say, I'll give you an example. As per the Indian custom and tradition, we see कि okay, हमने बेटी को तो शादी में जितना देना था सब दे दिया, अभी सब बेटे का है. So this is the normal mindset that we have कि बेटी को तो सब दे दिया है. So okay, if this is there in your mind, jot it down. Okay, this is the reason that during my lifetime I have given my daughter everything at the time of her marriage, at this time, at various occasions. Therefore, I do not wish to give any further share of the property to my so and so children. Please mention that. It becomes very imperative when you go to the court, when due to any reason it has to be taken to the court of law, and the person says ki nahi, they had forgotten, they just forgot to mention my name. So if it is written that okay, I'm giving it to ABC and I'm not giving it to D because of so and so reason, that will be helpful for us. You clearly mention how the properties and estate are to be distributed amongst the parties. It has to be the will has to be attested by 2 witnesses. It is very important that it has to be attested. So what the act says is that it has to be attested by 2 witnesses. What I particularly further opine is, mention their names, their addresses, their contact details also of the witnesses as well, so that tomorrow if the person has to be located, the person can be located pretty easily. Having a residual clause is also very important, that in case of any property which I might have missed out to mention in the will, or which I might have purchased after preparation of will. As I just said, okay, I prepared a will a few years back. Doesn't mean I'm going to die, and doesn't mean that I'm not going to earn and create new assets as well. So when the assets are created further, those assets can also be a part of the will with the residuary clause in place. This is the residuary clause, that in case I have missed anything above, or I have generated any other assets, those are to be given to so and so person. So that is a part of a residual clause. It is very important to mention that, because in case we skip that clause, then for those assets which are not covered in the will, again you will have to follow the entire procedure of getting the succession certificate and those documents from the court of law. As I said earlier, I will repeat it again. The language of the will should be simple, clear, and unambiguous. Keep it very simple, very clear, and very unambiguous. We don't want to put in the legal jargons which we would have learned over a period of time into the will itself. हाँ उसको तो डेकोरेटिव बनाएंगे, सिंपल बनाएंगे तो क्लाइंट पैसा नहीं देगा, डेकोरेटिव बनाते हैं, बड़े बड़े jargons यूज करेंगे, बड़ी बड़ी चीजें यूज करेंगे, डिफरेंट कॉम्प्लिकेशंस, ये करो नहीं तो ये करो, ऐसे करो वैसे करो. Don't do such things. Keep it simple, clear, and very unambiguous. Now, execution of the will. Execution of will means making the preparation of the will. It must be executed as per Section 63 of the Succession Act 1925. What are the ingredients? Execution means what are the preparations? It has to be signed by the testator. The person who makes it has to sign it. Now, another point. There are people in our society having multiple signatures. I sign like this in English, I sign this way in Hindi, I sign this way in so-and-so bank, in so-and-so document. Maybe 10 years back, I had a different signature, which I had mentioned in one of the banks, in one of the property documents. I have later on changed the signature. So, my opinion, affix all the signatures, all the different types of signatures, or affix each and every type of mark which you generally use in the will itself. It is not necessary that it has to be only one signature. It can be multiple signatures also. I sign in a specific manner in English. I write Hiral Shah in Hindi. I write Hiral Shah in Gujarati. So whichever format is there, which I normally use or occasionally also use all of them in the will. Affix a mark, affix your thumb impression, the left thumb for the male, right for the female. As the saying goes, ladies are always right, female is always right. So female right, male left. It has to be attested by 2 or more witnesses. Each of the witness has to sign in the presence of the testator. There is no particular format of attestation which is mentioned. Key witness has to do it this way or that way. No particular format, but my suggestion would be writing the name, address, Aadhaar number everywhere of each and every person. Who can be an attesting witness? Any person of 18 years or above of age can be the witness to the will. He should be reliable, responsible. It is advisable to have young attesting witnesses. Avoid having beneficiaries as attesting witnesses. Avoid having relatives of the testator as witnesses. So some of the witnesses could be friends, neighbors, co-workers. They are all great options. Now, just in a minute, why young witness? Say our general pattern is a person who is older will die first, younger will die later. So at the time of the execution of the will, if a young person has signed it, then the probability is greater that he would live more when the will has to be comes into picture. So at that point of time, okay, it can be recognized, okay, this is the attesting witness, okay, he is alive, and it can be said. Reliable and responsible. Person who is a witness. Any person, you take a pauper on the road, a beggar, and getting his signature wouldn't serve the purpose, because you the reliability of a person should not be challengeable. It should be very clear. So people who generally know you, your friends know you, the neighbors know, the co-workers know, those are good options. The testator has to can prepare the will himself or through the lawyer, the chartered accountant, anybody. So it is said that the lawyer or the chartered accountant is just helping them out. It's not preparing the will, it is just drafting and helping the testator to prepare the will. After the will is made, have the call the witnesses on a specific date and get it signed in their presence. Write down the date on the will. Writing of the date is very important because it is imperative for the person to know that on which date, when has the person actually signed the will. Again, the date, the relevance of the date, I'll come back in a minute. Testator to sign name on his will using normal signature, using all kinds of signatures and initials on all the pages. Initials is absolutely mandatory, I would say. However, if possible, have the complete signature on all the pages. Testator should ask the witness to sign the will as attesting witnesses. Okay, they have signed. Another myth which is there, which needs to go out of the mind, is that the witnesses would come to know that what I am writing in the will. Witnesses are just witnessing the fact that you are signing the will. They have no right under the sky to ask what is mentioned in the will. They have no right to see the will, nothing. They just have to attest the fact that, okay, yeah, this person and jobs on the will, and I would have number as well, if possible. Now, okay, these were who could be the witnesses. Now coming to the fact that who can be the executor and who is the executor. After the death of the testator, the property goes to the executor because the person is no more, and it goes to the executor who would finally be distributing it amongst the legatees. So the person, there is no restriction on the number of executors that you can put. However, the person that you select should be is your legal representative. So he should be at least of that mental capability to get the work done, to understand what is mentioned in the will. First of all, he would understand what is there in the will, and secondly, then he would execute it further. Then he would go further, and he is duty bound to distribute the assets among the assets of the testator as per the provisions of the will. So he has to see to it how the assets are distributed, and he cannot do it the way he likes. He has to follow what the testator has said. Now again, whom do you select as an executor? A person of good social standing, having reasonable knowledge about the workability. Better to have somebody of a lesser age, because again, as I said, the chances of somebody who dying first in first out basis, we can say, okay, who has first come in to the world goes out of the world first. So the executor is the responsible and accountable person. So he has to have good social standing. He should be a person who can put put his foot down and say, no, the will mentions this, so do it accordingly. So that capability should also be there. Then see, it is not necessary for you to explain the executor beforehand, that what you want, how you want to divide it. The executor would also get the will at the time of its execution, the final, when at the time of distribution and stuff, he would get the will. Not before that. It is not the duty of the testator to give it to the executor before, nor it is the duty of the testator to approach the executor. Okay, I'm putting your name, Mr. X name, into as the executor. So I need not ask the executor beforehand that whether should I put your name or not. However, it is advisable to put his name, his or her name, uh, before putting the name of the executor. Just contact them, because at times it so happens that the executor says, I'm not willing to do this job, I'm not willing to be the executor. So if the person is not willing and the testator is no more, so then again you have to get the letter of administration from the court, and such formalities increase. So make the executor aware or take his permission beforehand. That would be good, though it is not necessary, but practically it would be helpful. Who can be the beneficiary? So we understood who would be the attesting witnesses, we understood who would be the executors. Now let us understand who would be the beneficiary under the will. Any person capable of holding property can be devised under the will, and therefore a minor, lunatic, a corporation, a Hindu deity, or an artificial jurisdictional person can be a device. The benefits can also be given to unborn persons. Minor can also receive it, lunatic can also receive it, though the person who would be handling would be different, because unborn person, minor, lunatic, they are not capable of holding the property, but they can be the beneficiaries to the will also. Void bequests cannot be done. Say I say ki I mentioned in the will that 1 crore to be given to from Mr. A to Mr. B if and only if Mr. B kills Mr. C. No, such bequests cannot be taken. Those are illegal and cannot be taken. However, conditional will is possible. Say you donate so and so amount to so and so charity, then the amount will come to you. You fulfill this condition. The conditional will is possible. However, that condition should not be ultra vires. It should not be a void bequest. Impossible conditions. Okay, if you go to the moon, if you go to the Mars, if you go to some other planet, then only you will get so and so person, so and so things. So okay, moon, Mars, you can say it is possible, but logically it is impossible, and therefore such conditions would be void. Void bequests are also void ab initio. What can be disposed by a will? Basic point is you can will only what you own. This is the golden fundamental principle. I cannot will out India Gate or Gateway of India in Mumbai or Antilia building which belongs to the Reliance family. No, I cannot dispose of them by my will. I can only will for my property, for my assets, may it be movable or immovable. All the assets can be disposed by a will, but those have to be owned by me, not by anybody else. Now, this is a very vague example that I gave, that India Gate or Gateway of India or something. However, it so happens in the Indian society, as we say, that the head of the family. He is the person who decides everything for the entire family, without any specification, without informing everybody. Okay, all that is absolutely fine logically. However, it is legally speaking, at the time of preparation of the will, if it is if we say that a movable property or an immovable property belongs to me, I can will it. If it belongs to my wife can will it. If it belongs to my father can will it. But I cannot will it for my wife or my father or my children. It is not possible. I can only will whatever I own myself. Movable properties. Movable properties can also be willed out, are can also be willed out as good as immovable properties. All the properties have to be mentioned. Say articles lying in bank locker, FD, PPF, shares in physical form, demat form, mutual funds, debentures, ornaments, motor car, furniture. एट टाइम्स भी अरे फर्नीचर क्या होता है, अरे फर्नीचर में क्या लिखना होता है, उसको तो वैसे भी कुछ फेंक देंगे. However, we are speaking about specific furniture. I have a furniture which is some antique furniture made very specifically. A sofa set is worth 25 lakh of rupees. That can also be mentioned in the will. Specifically or generally, it can be mentioned. So these are also properties. My reason for writing down these things was we tend to forget them. कि हाँ ये फर्नीचर भी है, फर्नीचर हमने चेक पे किया था उसको 10 लाख का और दो 10 लाख का फर्नीचर आया था. Okay, that can be mentioned very well. Immovable properties like land building, so those we generally know about it. Now, under the Maharashtra Rent Control Act, sorry for the fact that I'm from Mumbai, so I know about the Maharashtra Rent Control Act. It is very specific that tenancy rights cannot be bequeathed under the will. Tenancy rights cannot be given a will because they are governed in Maharashtra, governed by the Maharashtra Rent Control Act. In other states, that various rent control acts have to be seen. So assignment of it is a right, it is not a property. When you are holding tenancy rights of a particular place, it is just the right as a tenant. You are not the owner of the property. The landlord is the owner. So landlord can have it in the will, but the tenant, it is just his right to stay, his right to use the property, but there is no ownership rights. So it cannot be bequeathed. However, practically, I would say that it is advisable to mention the fact of the tenancy rights as well in the will. The reason being, maybe going ahead, you have made a will today. Tomorrow you have a judgment of the Supreme Court of India stating that okay, tenancy rights can be given. So at that point of time, you would not sit and change the will. So rather, get it mentioned in the will. If it works out, well and good. If it doesn't work out, that specific clause is void. So that is okay. It is just a specific clause would become void. The entire will would not become void. So tenancy rights cannot be bequeathed. However, it is advisable to mention them also as a part of the will. Registration of the will. Under the Registrations Act 1908, registration of will is not compulsory. Absolutely, it is not compulsory to register the will. What we generally find is that there are people who don't have proper knowledge about the will. नहीं ये will registered नहीं है तो ये इसको will ही नहीं बोलते हैं. There have been cases which we have come across that big companies, big public limited companies, when a will is sent to them, transfer the shares, one line mail has come stating that this is not a will. How under the sky are you saying that it is not a will? It is, you can definitely sue the company for using such words. Even certain, the legal department also doesn't look into it. No, no, it is not registered. No, it is not a will. It is not in English, so it is not a will. No, registration is absolutely optional. It is not compulsory. However, there are certain advantages of registration which we would speak. So you can get it registered. It is at your discretion. It's your option. It is not compulsory. It is advisable to register so that the will cannot be tampered, destroyed, mutilated, lost, stolen. Say something happens, there is a fire. The original copy of the will is, say, if it is not registered and it is destroyed, then there is no will available. So it is intestate succession then. However, if it is registered, you can get it from the registrar and the will can be taken ahead with. Now, the burden of proving the will is propounded in the event of dispute of the execution becomes difficult, and becomes difficult to disapprove of the execution of the will if it is registered. So, as compared to registered and unregistered, the registered would have a higher weightage. The testator can alter the will at any point of time. You can prepare a will every day and destroy it every day. Whichever is the last will, that will be considered for taking it ahead. However, you can even have certain things like a codicil. The will is prepared, you need not change the entire will. Say you bought a new property and you want to give it to some specific person, you can add a codicil to the existing original will also, and that codicil would form a part of the original will only. Only the last will made before the death is enforceable under the law. Alteration of the will is absolutely possible at any point of time by codicil or by creation of a fresh will also. When you are creating a fresh will, follow the steps of the will. So all those things, new witnesses and everything would be new. By default, creation of a new will means revocation of the earlier one. So you can, by executing a new will, or you can revoke the will. You can even revoke the will by giving an by writing a declaration that so and so will which was prepared, I want to revoke it. No, not necessary that you create a new one. Even if you give a declaration, but this will, these wills which were prepared, this will or these wills, I want to revoke them, then it is revoked. Simple, by tearing it off, will is gone. See, then there is this query which generally comes in. The last will is, say, in the year 2019, a will is prepared and it is registered. In the year 2020, another will is prepared which is unregistered. So people have that notion that the one which is registered will be final, the one which is prepared later on, because it is not registered, therefore the registered one would prevail. The notion is incorrect. Whichever is the latest will prevail. The earlier one, even if it is registered, and the new one it is not registered, still the new one would prevail and the old one would not prevail. Requirements of a probate. Probate uh, is a document which we receive from the competent court, that the rights which are granted or which are claimed in the will are correct. So it is basically just a form of authenticated copy of the will which we get it authenticated from the court of law. There are various points wherein you need the probate. probate is mandatory in certain jurisdictions. That is the jurisdiction of Mumbai High Court, the jurisdiction of Madras High Court, wherein the probate is mandatory. Probate is a copy of a will certified under the seal of the court of the competent jurisdiction. It is a conclusive evidence of the validity and due execution of a will. So it gives greater power to the document which is already created. The procedure, it is quite simple, that an application is filed with the competent court, and the executor has to take the things ahead. The application is with the has to be done by the executor who takes things ahead. The application
So,
will, yes sir, yes ma'am.
so can we ask few queries
Sure.
right now?
Can I just end this probate thing and then we'll take it ahead?
Sure,
Is that
sure,
fine?
definitely. Yeah, sure.
Yeah. Thank you.
Thank you.
The court fees are also mentioned. It is a procedural aspect wherein we will have in most cases to approach the lawyer who get things done in a proper manner. So pre-formation of the will, appointment of executors, identifying the beneficiaries, witnesses, registration, alternate beneficiaries, residual clause is mandatory. Post-formation, these things are mandatory, and there is no stamp duty or income tax for the bill. Now the family Hindu undivided family. This is the portion which I am excluding out of it. Let's now take up the questions.
Yeah, sure. So
Yes, ma'am.
Amarjit Datra is asking if there is unregistered will by female, then what is the procedure regarding the same?
Unregistered will is very much a will itself. There is no, it is not mandatory to have the will registered, as I explained. So there is no question of a male or a female, registered, unregistered. A will is a will, and if the criteria of witnesses is fulfilled, then there is no problem at all.
Okay. Okay.
Yes.
So Advocate Gaurav Tana is asking, please cover how the fees is charged for drafting and execution of the will.
See, the drafting and execution of the will is basically depends upon the time and efforts involved by the professional when we are
Right.
doing it professionally. So it is non-comparable from one chartered accountant to another chartered accountant, or one advocate to another advocate. It is absolutely, it depends upon person to person. It's a
Okay.
drafting matter.
Right. So, Basant sir is asking, please do highlight about trust through will.
Okay. See, a clause can be mentioned in the will stating that after I die, the property would be uh, handed over to so and so people, and if those persons are incapable, so you can have the detailed drafting thereof stating that after my death, the assets would go to as a part of this family trust, a private trust. If it is a public trust, charitable trust, we are not talking about that here. Let's focus on the private trust, that it will be given to so and so trust. These persons would be handling it. Maybe the executors would be handling, or any person would be handling it for the benefit of so and so beneficiaries. So you have to define it in the will itself, that this trust can be created, the family trust can be created,
Okay.
and so person would be the beneficiaries, and this is how we would take it ahead.
Right. Okay.
Yes.
Nilesh ji is asking, what is the difference between nomination and will, and what will prevail first, nomination or will?
Sorry, that point skipped out of my mind.
Yeah.
Thank you, Nitin, for asking it. Uh, Difference between nomination and will. What we generally see is, say, as per the Cooperative Society Acts in various states, that say in for the property, with the society you have nominated, okay, after my death, so and so person is the nominee. And say in my case, I'll give you my example that in my property, I have mentioned that the nominee would be my wife. However, in the will, I mentioned that after my death, this property will go to my daughter. So, how it would go as the society would transfer the flat, would hand over the flat to my wife, who is
Okay.
duty bound to give it to my daughter, because
Okay.
what prevails is the will,
Nomination.
the beneficiaries in the will, and not the nomination. Nominee is just as good as a trustee, you can say, collecting the property from one person and handing it over to the other person. So this is the difference, basic difference between nomination and a will. However, nomination should always be done, and if possible, have the nominee and the beneficiary as the same person, so that there is no further conflict. It is advisable, but it differs from case to case.
Okay.
Yes, ma'am.
Yeah. Vipinji is asking, is it advisable to go for joint will in case husband and wife have joint immobile property and most of the deposits are in joint names?
Okay, this is again one of the very general query which comes up. We will prepare a joint will,
Right.
and so that there is not much of a problem. Both of us are joint owners everywhere, but the technical problem comes is if the will is challenged, one person is no more, the other person is there, and the will is challenged, then getting the probate from the court of law or fighting it in the court of law becomes difficult. It is one of the biggest challenges to get the things authenticated in the court of law when there is joint will. Okay, if both the persons die together, it is not a problem. Then it is greatly advisable. But that is not the general tendency. The probability is one person will die, then after a certain point of time the other person would die. So at that time the execution becomes difficult. Therefore the joint will or mutual wills are not advised, even if the property is a joint property.
Okay.
Yes.
That's great. Shivji is asking, is it necessary to give descriptions of all assets in the will? And what are the benefits to give description of all properties?
Okay. The advantage of yes, firstly, yes, it is mandatory. It is advisable to
Yeah.
have mention of all the properties in the will. If all the properties are not mentioned and the residuary clause is mentioned, then it will go as per residuary clause if specific mention of properties is not done. The advantage of having all the properties mentioned is that you can divide it the way you like. However, you are of the thought process ki everything has to go to X person. After my death, everything will go to my son, because there is nobody who is there in the family. So let the son enjoy everything. Then why do I need to have the effort of mentioning each and every item? However, apart from your efforts involved, one time effort involved of mentioning everything, there is no other great effort which is involved. So why
Okay.
not mention everything in the will itself?
Yeah.
It is
Right.
advantageous, definitely.
So Shivji is again asking, if I have to give all my properties to a single person and
Hmm.
I mention that Mr. A shall be the owner of all my present and future assets after my death, is there any problem in it?
Absolutely not. Absolutely not a problem. It is absolutely valid.
Okay.
However, still I would say mention each and every property, and then you give this definition. Okay, okay, all the properties which are mentioned above or my residuary properties all will go to Mr. A. Then it is
Sure.
absolutely valid, not a problem.
Okay. So just BG is asking, can a inherent property be disposed of by way of will?
Uh, yeah, there are for Hindu undivided family properties,
Right.
certain laws have to be followed. But overall, if the assets are distributed equally, even if you have received the property with unconditionally as per somebody else's will, you are the beneficiary of somebody else's will, and there is no condition thereof, you can easily dispose it off by way of your own will. It is valid.
Okay. Okay. So Surendraji is asking, can a beneficiary be an executor?
Uh, yes, beneficiary can be an executor. The
Okay.
challenge at times when we don't foresee some problems in a will. Okay, the family is settled, everything is there, everything is quite clear. If we don't foresee any major conflict, then we have multiple executors in the will, and one of the executor we mention as the beneficiary. The reason while executing the will, say I am the executor of 15 wills of various people, then and if I have to execute, I'm not going to get even a penny out of it, because it doesn't suit my profession. It doesn't suit my ethics to charge for helping out for the client who has always been with me. So I cannot charge, but I have to go to the court of law 10 times, go to various places if I am the sole executor. So I have a beneficiary who is also the executor. So that person he's going to get the property. So let him put in the efforts of getting the properties transferred. So
Okay.
beneficiary can be an executor.
Okay. That was right. So Amarjit ji is asking, if will is prepared for part of assets, that is only immovable property is listed, nothing above movable, is it valid will or not?
It is absolutely valid will. Even if you mention a few assets in the will, it is absolutely valid. The challenge would be that the residuary clause that would be used for your properties which you have not mentioned in the will. There is one wrong notion that generally people have. As I said, I make one will for the Noida property, one will for the Gurgaon property, one will for the proper Delhi property, old Delhi property, one will for the Mumbai property. That thing is not valid. Whichever is the latest one is will be considered, and then the residuary clause would work. So you cannot have separate wills for separate properties. But yes, in one will, if you want to mention only few assets, you can mention it that way. Though not advisable, but legally valid.
Okay. Nilesh ji is asking, do we have to obtain probate both the death of destination? Hello.
Could you please repeat?
Do we have to obtain probate post death of testator?
No, it is only in specific jurisdictional regions only where getting that probate is mandatory and under specific circumstances only. So, in all cases, say you are in Delhi and the jurisdiction of Delhi High Court doesn't require the probate, then it is not mandatory to get the probate.
Okay. So Nilesh, can beneficiary of the will be the executor?
Yes, I said as earlier, beneficiary can be the executor,
Yeah.
possible.
Uh,
No legal
Michelle,
bar.
okay. If the beneficiary is aware of all the asset, is it needed to mention in detail each asset or mention that all assets to be transferred enough? As we
Uh,
have already discussed, right?
yes, yes, and that is absolutely all right. If you don't
Okay.
even mention each asset, you just mention a blanket also, it is absolutely fine.
Okay. Amlesh is asking, mother have no earning income and not literate. Father has made property in mother's name. Can mother change the will after death of father by changing the will registered during the lifetime of father?
See, it is the mother's right. Once the father is not there and the property has been willed out in favor of the gentleman's mother, then the property belongs to the mother. Now, whatever the mother wishes to do, she can do with the property. So she can very well mention, she can very well prepare a will stating that these properties which I have received or which I have, which I am owning. See, it is properties which you are owning, whether you have earned it or not, whether you are literate or not, doesn't matter. But you should be aware that what you have written therein. So that is very important, that what is written in it, that should not be challenged. In such cases where the testator is not literate, we would suggest, and does not know any of the languages. In that case, we would suggest that get the will registered. That would have a shield against any future litigation. But it can be
Okay.
very well done, and she can change it at any point of time, even if it is registered earlier.
Okay. That was. So Shivji is asking, what if executor dies before the testator and testator could not change will and dies?
Okay. In that case, the advisable portion is have multiple executors. That is one. And second would be have a clause in the will stating that an executor, if he wishes, can appoint additional executors as well. That is also possible. However, that is not done, and the executor is no more. And then the beneficiary dies, then you have to get a letter of administration from the jurisdictional court.
Okay. Ashwinji is asking, can a shares be willed to my son and have a condition that on his death he has to will it to his son, that is my grandson.
Possible.
We can put a
Conditional
condition.
license. Yes, it is possible.
Yeah. Okay. So Mahendra ji is asking, if a person makes a will for some of the assets but not for all, whether the same is correct or not.
It is correct.
Okay.
Absolutely
Siddha-
valid, and it goes as per the residuary clause then for the
okay.
balance assets.
Siddhanji is asking, if nomination is in FD with banks, but in will,
Hmm.
all assets distributed equally, then which prevail? And if no will, then nomination will prevail or not?
See, if there is no will, then what is happening practically with Indian banks is, okay, this person is the nominee, they give it to the nominee and forget it. So the bank is safe that it is done. However, the law precisely says that the assets have to be distributed as per will. If there is no will, as per the relevant succession act. Now, the first part of the question, that nomination is made in favor of A. The property is distributed amongst ABC equally as per the will. In that case, the fixed deposits would be given by the bank to Mr. A. Now, Mr.
Okay.
A is duty bound to distribute the portion of, keep one part with himself and distribute the other parts with B and C also, because A is just getting the amount as a trustee. Say we want to give some amount. I want to say give 5,000 rupees to some party and get some goods from there. So I give it to my peon. Please go there and get it for me. So here my peon is just an a trustee on my behalf. Similarly, here Mr. A is just a trustee who is the nominee, and he has to give it to the real owners. The real owners are ABC equally.
Okay.
So nomination would is subordinate to the will. So
Well.
beneficiaries in the will are superior.
Okay. That is. So Bharti ji is asking, if a single woman has property, joint name mothers, who is no more, what is advisable? Shall I transfer on my name? If yes, what will be the procedure for it?
Uh, See, transferring of property. If it is an immovable property, then the relevant state acts come into the picture. However, the point is that once there are no other beneficiaries, there is nobody in the legal hair, and everything is fine, then get it transferred in your name by removing the other name and getting the documentation done. So you have to get the documentation done. Say in the state of Maharashtra, you have to submit the relevant documents to the society or whichever organization it is, and they will get it transferred in your name. However,
Okay.
if the opposite party asks for the letter of administration and various succession certificates from the court, then you will have to get it if the will is not prepared. Does not make a difference whether it is a joint property or not a joint property.
Okay. That is informative. So Rajesh ji is asking, in case of immovable property in joint name, whether share is as per consideration paid by each one of us or equal in all the cases
It is as per consideration,
as per the
or
consideration.
yeah, as per consideration, or if it is if it is specifically mentioned in the agreement that this would be the share, then it goes as per that. If it is not mentioned in the agreement, then as per consideration, and if everything is silent, then equally. So this is the
Okay.
hierarchy which we have to follow.
So Chaganji is asking, there may be any evidence that will is drafted by free will or by in sound mind.
Yeah, that declaration has to be made. Okay, okay, I have done. Okay, one more added thing I would say. uh, at the time of preparation of the will, one of the witness, the two witnesses are there. Apart from that, get the signature of a doctor's certificate who
Okay.
certifies that the person is of sound mind. Now, if I am a witness as a chartered accountant, I can say the person has signed in front of me. However, if you attach a doctor's certificate or the doctor signs therein that this person is of sound mind, that would be an added advantage, and that would be really good stating, because a doctor, a medical professional, can determine your mental stability. A chartered accountant cannot define that, or a lawyer cannot do that. However, a doctor can do that. So always it is advisable to attach a doctor's certificate or draft a point and get it signed and sealed by the doctor. So
Okay.
that would prove the mental capacity.
Yeah. Right. Siddhanji is asking, if nomination in FD with banks but in will all assets distributed equally, then which prevail? And if no, will that nomination will prevail or not?
It is the will would prevail over the nomination. Will is a higher thing. A finality comes by the will, not by nomination.
Okay.
Nomination is just a transient provision.
Right. Surendraji is asking, do we need to fix the photographs of the witnesses?
uh, when when you're getting it registered, at that time the registrar asks for the photographs mandatorily. However, generally for witnesses the photograph is not required. It is advisable to have it for the testator himself or herself, not so much required for the witnesses.
Okay. Shailendraji is asking, if there is no nomination in bank account by mistake, but included in will, then will be the honored or not?
Yes, it has to be honored, because that just it is the nomination is just a transitional provision. The bill has to be honored, and you have to put your foot down with the bankers, because bankers themselves, many of the bankers, they do not know nomination नहीं है, हम नहीं देंगे, आप कोर्ट से ऑर्डर लेके आओ. Here there is the bill, you have to follow the bill and get it done. So
Okay.
will prevails even if there is no nomination.
Right. Mahendraji is asking, can there be oral will in case of a soldier who is fighting the enemy at the time of war and dies there only? Then will an oral will work or not?
Yes, it is known as a privileged will. When it is for the armed forces, a privileged will, it can be oral. But for other than armed forces, it is not allowed. For armed forces, it is allowed. It is known as a privileged will.
Okay.
Hello.
Yes, sir.
I
Hello.
queries are coming, but because of the limitation of this time, we are not able to take all the queries. We are sorry for that, and really, big round of applause for you for such a wonderful deliberation. I am really thankful to you for guiding us regarding the will nomination and even drafting. Even members are so happy. But yes, limitation is with us. We can't take even queries are coming. So once again, my thanks to all of you and thanks to all our moderators, CA Priyanka Jain ji, CA Ashima Agarwal ji, for such a wonderful presentation. So thank you very much once again.
Thank you, sir.
Uh,
Thank you so
Stay
much,
home,
sir.
stay updated. Thank you.
Thank you so much.